Hello and welcome to another episode of the Opus Well Style podcast. My name is Iván Watanabe, here with my partner, Evan Wohl. Evan, what's going on, man? How are you?
Doing great. What's going on? How you feeling today?
I'm doing well, man. I'm doing well. First day of October as we're recording this today. And we're excited to have on Jim Magner. Jim, welcome to the podcast again. And I say again because we're having to redo a previous episode. Jim is one of the greatest resources that we have available to our firm and partner to our firm. A super talented attorney, and we're excited to have you on, Jim.
Thanks for having me.
Absolutely. So the reason why we have to re-record the previous podcast is the last time we were on, we were talking about the FTC, talking about non-competes and what potentially was coming down on September 4th. And some things have changed since the last time we talked. So, why don't we just kind of update the audience on where we are today as it relates to the ban on non-competes?
Sure. September 4th was the effective date of the ban. FTC announced in the early spring that September 4th was the target date. September 4th hit, and I think 5 plaintiffs around the country jumped into federal district court saying, hey, the FTC doesn't have the power to do what they're doing. This is not as part of their charter. And lo and behold, on August 20th, a federal district court in the Northern District of Texas set aside the FTC's non-compete rule and ordered that it can't be enforced nationwide. So it wasn't just applicable to Texas. So everything, all the buildup, all the excitement, the fireworks, hey, non-competes are gone, timeout, everything comes to a screeching halt, and now it's appealed by the FTC to the Court of Appeals for the Fifth Circuit. But I guess the punchline is the FTC can't enforce the rule against any employer nationwide while this litigation is going on.
Cannot, you said?
Cannot, correct.
Mm-hmm.
And, one of the things that we were talking about previously is sort of the responsibility of the business or the business owner to create a letter to notify employees that they could, in fact, take the information and go elsewhere. And we had to actually provide employees with that document, right? And that was a responsibility of the employer. And so it's been a completely different approach over the last few months. What have you been sort of talking to with business owners, still recommending creating a letter, notifying folks? Like, what's the responsibility that business owners have today?
Yeah, good question. I know a lot of folks with non-competes who didn't get letters. I think a lot of folks were handicapping this from the springtime when the FTC announced their proposed rule. And they said, you know what, given the tenor of the Supreme Court, the major questions doctrine, we're not going to send the letter out. And I think if you polled most employers, they didn't send the letter out on September 4th. And I think they were pretty smart in not sending that out. If you look back and it's almost like sports. As a quarterback, you got to look down the field. As an employer, you got to take in all these different inputs. And I think the smart money said, you know what? Trump kind of sort of packed the federal district court level with a lot of conservative justices. And there was a good chance that they'd march into a federal district court like the Northern District of Texas. They forum shopped and, they got what they wanted. So, and that wasn't the only court that said, hey, time out, FTC. There were, I think, 2 or 3 others that said the same thing. So, a lot of buildup, a lot of press. Lena Khan, the head of the FTC, was on the nightly news a bunch of times, testified in front of Congress, and everything's now kind of on hold.
So are we back to where we were before this whole thing started, or are we in some murky middle ground?
I review a ton of employment contracts, doctors, dentists, senior executives, and I just reviewed one about an hour or 2 ago, and it had a non-compete in it. So I think what I'm seeing is that most employers are saying, hey, you know what, we're just going to, it's business as usual. We're just going to do what we've always done.
Mm-hmm. And what would you say is the next steps? Not necessarily for employers, but for the law.
Well, I think if you look at the Supreme Court and the decisions that have come out in the last term, they flipped the Chevron doctrine. They introduced this major questions thing. There's definitely a change in how federal courts are looking at regulatory agency pronouncements and regulations. In the past, they gave deference, quote unquote, to the agency. They were required to do that under the Chevron Supreme Court case, and Chevron got tipped. And I think a lot of federal district court judges are saying, "Hey, you know what? We're not just going to take for granted what an agency says. We're going to look under the hood of these rules. We've been given the green light to do so by the Roberts Supreme Court." And it's not just non-competes that are at issue here. I think a lot of agency pronouncements. I used to work for the IRS. They push out a lot of guidance, revenue procedures, revenue rulings, proposed final regulations. I think a lot of agencies are recalibrating how they do what they do in light of the change of temperature at the Supreme Court level.
And for the employees right now, when they're starting, specifically doctors, or I know we've had conversations previously about the non-competes inside of their contracts. For all intents and purposes, right now they should be evaluating those non-competes and really just as if nothing had ever happened, right? They really should be saying, or if there's one in their contract, negotiating it away if it's possible, or making sure that they have clarity around that part of the contract. Is that fair?
Yeah, it's really fair. I mean, when I look at it, like this morning, I looked at a doctor's contract and proposed contract. And, I screened for a whole bunch of issues. Non-compete's just one of them. You got med mal, you got tail coverage, you got forum. Where's this thing going to end up if it results in litigation? Is it arbitration? Is the signing bonus subject to clawback? What do the WRVU components look like? Are there incentive comp? There's a doctor's contract is a pretty complicated animal. There are a lot of moving parts, but docs like to move around. They get better offers. They move around the country. A lot of them want to do research in a different facility. So there's a lot of moving parts you have to look at, and non-compete is just one of them for me.
Do you think the Chevron deference tipping the other way has started to make meaningful impact, or it's going to take more time for that?
Yeah. That was one of the most important decisions in the past 50 years, I think, from the Supreme Court. There are three coordinate branches of government, right? Legislative, executive, and judicial. And you have this ebb and flow over the history of the United States as to who's supreme. Is it the executive branch? Is it the legislative branch? Is it the Supreme Court? The Supreme Court basically said, "Hey, time out, guys. The judicial branch has the ability to tell the executive branch that they don't have the authority constitutionally to make these kinds of rules." And the FTC non-compete ban was one of them. If you look at the FTC's charter, you can say, "Hey, where does Lena Khan get off saying that non-competes, which is typically a state law issue, it's not a federal issue, where does she get off injecting the federal government into state law employment contract negotiations or employment issues?" And I think there's a valid point there. Every state has. I'm in Massachusetts. We have our own laws with regard to non-competes. They're not as aggressive as some other states. Like in California, constitutionally, basically non-competes, you can't do them. You could never do them. So you look at all those high tech companies out there, those people bouncing around from Apple to who knows where. Non-competes just don't exist in Cali. In my state, Massachusetts, they exist, but there are some restrictions as to what employers can get away with. But up to this point, it's always typically been a state law issue. And I think the Supreme Court has signaled, we want this to continue to be a state law issue.
And if it's a state law issue, Jim, and you have a company like Apple, for example, where their headquarters are in one state, but the employee lives and works in another state, where does the non-compete? If they're in California, and they live in New York, does the non-compete apply to New York, or does it apply to the regulations in California?
Now, the laws of where you live, your situs, your domicile, govern what your employer can get away with. There have been a few cases out there where folks have said, hey, I think this employer is going to make me sign a non-compete. I'm going to move to Cali. And the courts have said, hey, time out. You can't do that end around. The rules of your state apply to, your non-compete. If the person had, not just jumped into California and, let a couple months go by, if they've been there for 5 or 6 years. But it's kind of interesting to see the gamesmanship that's played between employers and prospective employees on this issue.
Interesting. So going forward, what should employers be thinking about, or employees be thinking about as this plays out? Is it just keep informed, and if something changes, make sure that you're prepared to make the sort of pivot, or what do you recommend for people?
Well, keep your head on a swivel. We might get regime change. You never know what's going to happen in this election. If we have an R in 1600 Pennsylvania Avenue, Trump's no friend of banning non-competes. So I think it starts there. This issue will just vaporize if there's a Republican in the White House. But as an employer, as I said before, you get a lot of inputs. As a business owner, you got to keep your head on a swivel with regard to these cases. I eventually think this is going to go to the Supreme Court. I think the FTC will lose there. I don't even know if Lena Khan will be there to, this might be after the election, most likely. But it's just a fascinating interplay, between the coordinate branches of government. For a political science major / attorney, it's just fascinating for me to see how this one plays out.
I love it. Well, appreciate the insight, Jim. Again, I know we're updating our previous episode from a few months back. But before we head out, any other things that you think the audience should know or think about or consider as they go forward?
Yeah, I think prospective employees need to do the right thing and get representation. I see a lot of docs, especially younger docs. They don't have a lot of money; they get a lot of debt. It's hard for them to afford a $500 an hour, employment law attorney, and it's worth every penny. There's a lot of junk in these employment contracts. I think it's really worth the effort to get someone who knows the lay of the land to review this stuff. And on the employer's side, you don't want to have any footfalls here. If the ban is held up, and an employer sticks one of these things in a contract, you can bet your bottom dollar the FTC is going to be auditing, and there are some major penalties that would have come across the bow of that employer if this ban had held up. The last thing you want is to be audited by a major federal agency that has unlimited resources. So. I just think it's important on both sides that they get the right representation, or else, some bad things could happen.
Absolutely. Well, Jim, appreciate you joining us again, as always, for the quick episode. We want to make sure we get this information out to the audience as soon as possible. Appreciate you, and thanks for the time. And to you, the listening audience, make sure to click subscribe below to be notified when our next episode comes out. Appreciate you, Jim.